So that's me, Gary Lambert. That's me outside my office in Boston, Massachusetts. The name of the firm's Lambert, Shortell and Connaughton, and all we do is intellectual property law. That's a big umbrella for what we call patents, trademarks, copyrights, trade dress, and that's all we do. I primarily do litigation, so if you get sued for trademark or patent infringement, I handle that. You want to sue somebody, I handle that, but we handle copyright applications, trademark applications, do all the soup to nuts. That's my card. I've got plenty of these cards up here if you want one. I got my cell phone on it. I know we're in Boston and in New Hampshire, but because we do federal patent and trademark law, I can practice anywhere in the country. So I don't need to be licensed in Kentucky or out here, down here in Tennessee or anything like that. So anyway, moving on. When I'm not hunting, when I'm not practicing law, I love to hunt. So I'm not a hunting retailer, but I know a lot about hunting. I've been doing it my whole life. And Paul, as I was telling you, that's a buck I got last year in Ohio. I decided to shave for you guys today. I don't normally like to shave when I'm out hunting, but I got cleaned up. I also, on the side, I got a small little guiding business, and not only do I get trademarks, I've got a registered trademark. That Sepify Hunt is a registered trademark with the U.S. Patent and Trademark Office, and I do that, a little bit of the everything you see on that. You can see I'm a master guide in Maine, licensed guide in New Hampshire. I really love the outdoors, and like I said, I'm out there as much as I can when I'm not practicing law. All right, on to the subject matter. You didn't come to hear about me or see my deer pictures. What is a trademark? It is a brand. That's what it is. And what is a brand? It's anything. Names, symbols, slogans, anything to identify and distinguish the goods and services of one seller from another. It also indicates the source of those services or those goods. But that's what it is. Walk around the show, I decided to pick out some of the trademark and service marks that you see at the show. I'm sorry if yours is not on there, Paul. I didn't know you then, otherwise I would have put you up there. But here's something to think about right off the bat. These are all what we call design marks. So trademarks, there's two types. There's a word mark, W-O-R-D. I've got a Boston accent, so I'm going to try to spell out some of these things that I may not be clear on. And then there's a design mark. These are all design marks. Even Spot Hog, that may look like a word mark, but there's a design in it. Design marks are always weaker trademarks than word marks, always, because you got stuff in them. So like, take Alaska Guide. I like those guys, I got their stuff, but they got the mountains, they got the bear paw in there. The reason why they're weaker is if someone else comes out and says, hey, wait a minute, I'm not using the mountains, I'm not using the bear paw. There's more of a likelihood that they can say there's no likelihood of confusion, and that's the test. We'll get into that in a minute. But you always want a word mark if you can get a word mark. If you can't get a word mark, then the design mark is a good fallback, and if you got tons of money, you want it all. You want every design mark you can come up with. All right, moving on. How many, you may come up to me and say this too, but how many people come up to me and say, I want to trademark something. I want you to trademark something. That's not what I do. You guys get the trademarks. I get the registrations. It's a trademark registration down at the patent office. So getting a trademark, I know it's a slang word that we use, is not something that's in my vocabulary. It might be in yours. But I understand what you mean when you say I want to trademark something. All right, that's what you want, a registered trademark. That's what I'm in the business of getting for my clients. That's what I'm in the business of enforcing when we do trademark infringement. But that means you went to the Patent and Trademark Office said, yep, we bless you, give you a registered trademark, and guess what? Those things are good forever and ever and ever as long as you pay your renewal maintenance fee. First 6 years, after that every 10 years. All right, now if you don't have a registration and you've got the trademark, then you've got common law rights to trademark. And that's a TM. A lot of people put TM next to their trademark. If you see that, that means they probably haven't registered. Now, they could have registered. You saw my business card. I had nothing on it. Nothing about an R, nothing about a TM. So sometimes you don't know, but if you got them up there, then people do know what you got. And if you got a registration, I'm going back to this slide, that lets people know, hey, wait a minute, this guy, you know, maybe we shouldn't mess with him, or maybe we shouldn't get too close to him because he's got a registered trademark. All right. Common law trademark rights. Unlike a lot of countries, you get immediate rights and protection just by using your trademark. Okay? You go out there, it's nice to have a registration, you don't, no big deal, because in the end, it's about who's using it first. So you get rights solely by using the mark. Now, this only exists where you use the mark. Now, that used to mean something years ago, because I'm dating myself and you see the gray hair in my head, but I did this before the internet. So back in the day, if you were mom and pop on the corner, and you were mom and pop in, say, you know, little town in Texas, that's all your common law rights were there. Now, everybody's on the internet. No matter what your budget, everybody's got a website, which means you're nationwide, you're globally. All right, like I said, people come to me because they're not content with just having a common law trademark. They want a registration. You got to go to, there's only one place to go, United States Patent and Trademark Office. All right, so I brought this up, Spot Hog, they're up here. I love their products. Got their release. I'm a big bow hunter. I got their sites. So I'm going to use these guys as an example. I'm going to take you through, show you a little bit about what a registration looks like and the important things to look at. All right, up at the top, international class. There are 45 classes at the trademark office. You do not get a trademark on your name. You get a trademark in a class and for something, either goods or services. Nobody owns a name. Okay? Spot Hog doesn't own the name Spot Hog. They got a trademark for, what is it? Archery equipment. Class 28, which is probably most of the people in this room, get this, is toys and sporting goods. So all you sporting good manufacturers are also in the same category as the toy guys and gals. Kind of crazy, but there's where you're at. All right. So next thing to look at, data registration, that's important. Principal register. There are 2 registers down at the trademark office. You want to be on the principal. That's the best one. If you can't get there, you're on the supplemental. That means you have somewhat of a generic trademark, a descriptive trademark with no secondary meaning, which means the consumer does not associate, like Spot Hog is a well-known name. If someone just came up, it's a good example, best archery store in the world. That's a merely descriptive name. You're going to end up on the supplemental register until you can show the trademark office that you've got a secondary meaning with the public, saying, oh yeah, best archery shop, I know who those guys are, right? Okay. Here's another thing. So this is important. Every trademark has to have for something. Also on every registration, you're going to see first use. In the end, first use rules the day. The trademark examiner can only deal with who filed first. But in the end, if you got a fight with someone, it's always about first use. You got a question? No.
What is considered first use?
Okay. The question is, what is considered first use? It depends. For goods, putting a trademark on goods and selling them, or offering them for sale.
To the public.
To the public. Right. That's correct. Guess who the public is? Everybody but your lawyer. Because your lawyer, you got the attorney-client confidence, privilege. Everybody else, they're the public, okay? Now, so that's what first use. Now for services, it's even less. A business card. Print up a business card. Go to, any cheap place that makes business cards, and all of a sudden you've got a specimen. Boom, you're done. So goods are a little bit more. Does that answer your question?
Yeah.
If it doesn't, we got we got plenty of time.
I don't want to, we'll talk.
Okay.
First use is confusing to me because you say to the public, but what's considered for sale to the public?
Yeah.
You build a website, you don't even have the product in hand.
No, you've got to have the, yeah, okay, so let's clarify that. And so the question is, once again, what is a public use? What is first use? You take a trademark, you put it on a product. You offer that for sale. It doesn't have to be on the website. It can be anywhere. It can be on right out beside your house, on the street corner. That's first use. Plain and simple. It doesn't have to be pretty either. For a word mark, you don't have to have any designs, nothing, okay? All right. Just as another example, Victory Archery, they're here too. Once again, just to go over it, you got the registration number, when it was registered, there's that International Class 28 again. For archery arrows, once again, there's your first use. Now, I'm going to clarify something I should have brought up before. Back in the old days, this meant something. First use, notice you see first use and then first use in commerce. Back in the day before the internet, first use was, okay, so you go outside your door, you put your name on something, you put it on your product, now you got first use. In commerce meant interstate commerce. You actually had to like go on TV or radio across state lines. Now, what do? You go on the internet, boom. Not only do you have interstate commerce, you got global commerce. So what I'm saying is back in the day, sometimes those dates used to be different. Now those dates are basically the same. Because most people start out with first use on the internet. All right, any questions on that before we move on? Like I say, feel free to raise your hand. We got very few people here. We can handle that. Why do you want to register? A lot of reasons. Legal presumption of ownership. Notice I've got state registration up there. That used to mean something back in the day, once again, when I was doing this before the internet. You go to the state Secretary of State's office, get your state trademark application, registration. It meant something. It hardly means anything anymore because everything's global, everything's national. So you got a registration here in Tennessee, you can't enforce it outside of Tennessee. All right, public notice, claim of ownership. People, as I was talking to Paul here, who runs this great coffee company, Hunter's Blend. Right, it's Hunter's Blend, right? Yeah. Everybody finds everybody that wants to find anybody. You punch in Hunter's Blend, a lot of things are going to come up. Your website's going to come up. The trademark office application may even come up. Whatever, you know, it's amazing what you'll find on the internet. You guys know that, you're in the business. You get a listing in the USPTO online database. Here's the really cool thing. You get to record that with the U.S. Customs and Border Protection. Well, that's really important now because, you know, as much as we like China and all they do, a lot of counterfeit material comes out of China. We know that, and if you've registered with the PTO and with Customs and Border, now they'll prevent the stuff from coming into the country, the counterfeit materials. All right, you get a right to use that federal registration symbol. Once again, a big deal for a lot of people that know what they're talking about, know about the registration. And the coolest thing for me, as a litigator, you get to go to federal court. You want to be in federal court. You do not want to be in state court. It can be a mess. A lot of the judges aren't too familiar with trademark law in state court. And so usually when you go to federal court, judges have a lot of experience with it. You want an experienced judiciary. And you got a registration. You can also go to foreign countries. Now, a lot of people come up to me and they say, I want an international trademark. No such animal. I want an international patent. No such animal. Every country's got their own gig. But if you've got a registration here in America, you can use that as your filing date in the foreign country. So you get like a Benny by doing that. Because we've all got treaties with all the, you know, developed countries. All right, questions that client asks me, like I say, feel free to ask me anything, but this is what I get a lot in the office. So I wanted to bring them up and talk about them. Can you trademark this name for me? Once again, I am not in the trademark business. I'm in the registration business. You're in the trademark business. That's what you guys do. Can I get a trademark if the name is not taken? Hear it all the time. It's like they think it's like GoDaddy. A lot of clients think you go in there, you go to GoDaddy, you plug in your name, and instantly you find out I can get a domain name. Got nothing to do with the trademark office. It doesn't work that way. Names are never taken, by the way. No one can ever get a trademark on a name. You get a trademark on a name that's associated with goods or services, but you don't have a lock on a name. In other words, once you get a trademark, you can't say, oh no, you can't do that. You're in the porta potty business. You can't do that with my name. Nah, there's probably no connection between what you're doing in sporting goods with the porta potty business. Okay. Can you see if that trademark is available? Again, got nothing to do with nothing. Whether it's available, you can go in there and there might be 10 trademarks, all got the same name, but they're all doing something different. So everybody gets to get one then. Now, that said, don't run with that and say like, okay, I want to call myself, Rolex Arrow Shop. Because if you've got a famous trademark, you get more rights by having a famous. So because you're Rolex, people are still going to say, wait a minute, you must be connected with Rolex watches. That likelihood of confusion means you're not going to be able to get that registration. Okay? All right. I did my own search and I did not find that trademark. Am I all set? No. Let me tell you why. Let's move on to the next slide. If you finally make it through the maze that's at the trademark office as to how to do some searching, you're going to end up on this page. This is what it's going to look like. And they're going to ask you to put a search term in there. And if you don't put in exactly the right word, what's going to come up is this. And I'm sorry, I couldn't make this any bigger. I'll read it. No TESS records were found to match the criteria of your query. So as a good example, Spot Hog is out there. Like I say, I like those guys. They've got some good products. If you put in Spot Hog and spelled it H-O-G, this is going to come up. And you're going to think, geez, Spot Hog ain't taken. So why not, I don't have two G's, they got a G. No, it doesn't work that way. It's all about a likelihood of confusion. And that's why this is probably one of the most misleading things that I see clients undertake. It's just, and the trademark office, I don't know, maybe they're doing the best they can, but it doesn't work out for a lot of people. That's why they hire lawyers like me, because we know how to navigate it. But, okay. This is it. As I was telling Paul, probably 50% of my income, what I make, is based on these three words. Likelihood of confusion, the most common reason to reject. It is also the same test for trademark infringement. So whether you're trying to get a registration or someone is infringing you or you might be infringing someone else, the test is whether there's a likelihood of confusion. Two criteria, and you need both. The marks are similar. Notice I did not say the same. Similar. And two, whether they're related, such that the consumer would think there's confusion. Not you, the retailer, not me, the lawyer, but the average Joe Jane out there being the consumer. That's the test. All right. Like I say, you got questions, ask them. There'll be time after we get done, but if you got them now's a good time. I'm sorry that this is I couldn't make this bigger either. But this is what the trademark office tells you, right? Similar to your trademark used, and it must be live. I don't know if any of you have gone and tried to do a trademark search on your own or whatever, but a lot of times you're going to see when you look, the trademarks that come up, it's going to say whether it's live or dead. That's another really misleading area because people see dead and go, hey, the trademark's available. You know what that means? Somebody forgot to pay their maintenance fee. They're still out there. They're probably still out there in business, still doing their thing. What did I say about first use? always going to rule the day. So you could come in, perhaps even get the trademark, maybe have it for several years, and then meanwhile they're like, whoa, you know, we forgot to pay the maintenance fee. We've been out there doing this for 20 years. Say your archery shops, same name, you got a problem. All right. Now, I got some examples here because examples are always good. You can't argue with these examples. I did not make them up. I got these off the Trademark website, Trademark Office's website. So, one example. Say you plugged in, your mark is T-Marquee, you plug in T-Marquee and nothing comes up. That right there, if that was out there, they're going to reject you on it. That's a similar name, even though it's spelled differently. Looks differently, everything. All right. Sound, appearance. Even though you look different, same name, that makes sense. Meaning, what's lupo? Anybody know what lupo means? You know it means wolf, because it makes sense up there, but anybody know what language that is? Italian. Thank you, very good. So, I mean, who would have known, right? Lupo, wolf, you think they're two separate, totally different names? Nah. The trademark office is going to ask you, when you come in with lupo, they're going to be like, what's this mean? You always have to explain things that sound funky, something different. All right. Commercial impressions. That's fairly simple, but how about this? City woman, city girl. Two different names. Talking about the same gender. All right. Goods. So remember, you got to have similarity. Now you got to be related to the goods. T-shirts and pants, hats are related. Banking services, mortgage, related. T-shirts, online retail, clothing, related. All right. Other grounds. This is going to maybe blow you away because there's a lot of exceptions to this. But this is to get a registration. You cannot get a, like if I wanted to open up Lambert's Archery Shop, I'm not going to get a registration. I may be able to get on the supplemental register because I'm a surname. Nobody understands that, right? If you're primarily geographically descriptive, I know what you're going to say. Well, like what about Lancaster Archery Shop? They've got that secondary meaning. I think most of you probably have heard of them. That means they've got inherent distinctiveness. They get to get on the principal register. You want to open up Nashville Archery Shop, I don't know if there is one, but that's probably going to get rejected on the principal register. Okay? Now, once again, you're in business, you stay in business, people associate you with that name, you're going to be able to move into the principal eventually. And then, here's a new one, because like I said, I've been doing this 36 years. Disparaging or offensive trademarks used to be rejected until just a few years ago. And the seminal case on disparaging marks was a band of Asian guys who called themselves the Slants. Trademark office said, that's disparaging. And they said, oh yeah, we want to call ourselves the Slants. They took it to the Supreme Court. Supreme Court said, okay, there you go. And then this other guy came out with FUCT. That was just a few years ago. He got rejected at the trademark office. He took it all the way up, went to the Supreme Court. You get to get an offensive trademark if you want one. So this is all brand new territory. This is just within the last couple of years, folks. So, I mean, you take a history of this country and now all of a sudden here's where we've gone. But maybe there's where we've gone as a country, right? All right. Other grounds for refusal. You got a foreign term that's merely descriptive, just like if you've got an English term that's merely descriptive. Nope, you're not going to be able to get it. Until you develop a secondary meaning and distinctiveness, etc. All right. Same thing with an individual's name or likeness. You can't do that. Title of a single book. You can get a trademark on a series of books like Harry Potter series. That's one thing, but not a specific book. And then matter, I get this all the time, matter that is used in a purely ornamental manner. I mean, you go through like downtown Nashville, you know, the t-shirts. If you want like Let's Roll, you guys know that came from, you know, Flight 93 on 9/11. Maybe you could start a clothing company called Let's Roll, but you cannot go Let's Roll on a t-shirt I want to trademark that. That's ornamental. Okay, so no ornamental stuff. Spot hog archery, so they can have a spot hog on their shirt, but if it was merely ornamental reasons, negative. All right. I use this as an example. Paul, I know I was talking to you about this. Paul's got the best coffee on the floor. I think you got the only coffee on the floor, right? But it's good, really good. But here's the latest case I could find, hunting related, trademark, just came out, just filed 2020. But Deer Camp Coffee sued Deer Camp Beer. Actually, it's the Upper Hand Brewing Company, but for trademark infringement. And the story behind this is these guys here tried to register their trademark, got rejected by the trademark office based upon this, undeterred said, you know what, we're going to make it anyway. So Buck's Bait, who owns that Deer Camp Coffee, decided to sue Bell's Brewery for that, claiming that there is a likelihood of confusion, that consumers, coffee, beer, two different drinks, but that they're related, where people would say, yeah, you guys are probably connected. All right. Oh, they just got filed, so we're going to wait to see. Now remember, these guys have been rejected twice at the trademark office. So if I was a betting man, I'd be willing to bet that these guys would probably come out the winner. Don't know though, but that's what I would venture to guess. Trade dress. I was almost hesitant to even mention this. This thing is wild, right? I mean, this stuff is wild. It's anything. It's just about anything you want. Like, oh, hey, by the way, I got a green chair. Well, that's trade dress, okay? And I'm going to use an example in here, but basically it's anything. Unless you got any questions, raise your hand. But here's what you got to do. You got to be distinctive, and it can't be functional. So if this green chair, if there was a reason for it, functionality, like it kept it cleaner longer because it was green, that's not going to work. But let me give you a good example. They're not here on the floor, but I found these guys. Carbon Express Maxima arrows. See the red? Guess what? They've got and you can register a trademark, a trade dress, at the trademark office. They've got a registered trademark on the red part of that arrow. Pretty cool. I mean, who would have thought, right? But, and I know you can't read it, but it says, the color red is claimed as a feature of the mark. And then it describes where it's at. And they've also got another registration on black with the red in the middle. Okay? So don't be going out there making an arrow with a little bit of red on it, because you're going to be violating that trade dress. Okay. Moving on to another subject, same office, U.S. Patent and Trademark Office. Two different buildings, two totally different operations, but this is what a patent is. It's a right to exclude others from making, using, selling, offering, da-da-da-da-da-da-da. They really mean that. Now as a retailer, because you guys are retailers, guess what? Offering for sale or selling. So if you're actually selling or offering for sale a product that's infringing, you guys are infringers as well. Crazy, but that's the law. Now, here's another thing about patents. Patents do not make you any money. Well, they can, but this is the intent. It's really not about you, it's about others. The value of a patent is preventing others from making money. Now, you might be able to make money off of that. You might be able to sell that right to make, to be the only person making a certain arrow. But that's the value of a patent, is preventing others. And utility patents for 20 years, design patents for 14. All right, types of patents. I'm sorry I couldn't get this any bigger. I just kind of wanted to give you a quick overview. There's 3 types. I know you're not in the plant business, but there is a thing called a plant patent for an asexually reproduced plant. But the main patent you want to try to get, if you can, is a utility patent. That protects the function of a device, no matter how it looks. It's the toughest thing to get, but it's also the best. All right? And then there's design patents, ornamental features. Nobody came up with a chair, or nobody invented, well, Not that I know of. I don't know if a chair's ever been patented, but maybe you've got an ornamental design for the chair. That can be the subject of a patent. All right. 2 things to get a patent. There's 2 words, but they're both fairly complex. We'll talk about them a little bit. You must be novel. They really, really, really mean this. People normally nod their head like, yeah, I know I got to be new. No, you got to be it. You got to be the first person to ever do it. So like if Johnny in China, Mary in Germany did this before you, even though they never got a patent, hear that, whether they got one or not, if you're not the first person to do it, invent it, you don't get a patent. Now, people always ask me, I know, like I say, feel free to raise your hand. Well, how are they going to know? How's the patent office going to know whether Johnny did this in China? They may never know, but here's what happens. You get a patent, you go to sue someone, and the first thing I do, being, a litigator, patent litigator, I start looking for that prior art, what we call prior art, prior stuff out there. With enough money, I'm probably going to find it. And I'll get to a case in point about the Garmin, the site, both site, and we'll talk about how that happened in that case right there. But just so you know, like I say, you're going to be the first guy to do it. And if that weren't tough enough, you can't be obvious. And people turn to me and say, what the heck does that mean? The examiner cannot, the examiner at the Trademark and Patent Office cannot say, this is obvious. No, they can't say that. But what they can do, this is what they do to come up with an obviousness rejection. Oh, you're new, I can't find you in a single patent, but I'm going to combine patent A with patent B, and if I combine those 2, I get you. So that's the combination rejection, we call it, okay? And that's the most common rejection. A lot of people are new, but just because you're new doesn't mean you get a patent. All right. Sorry, I could not make this any bigger, but this is, I just kind of want to give you guys a feel for, this is a design patent. That's it. You can't talk about what it does, how it does it, none of that. It is what it is. There's a drawing, that's all you got, okay? You can tell a design patent by up at the top and it'll have a D in front of it. That's a bow sight. Now, we're going to get into a utility patent that probably all of you have heard about. I thought about buying one myself, maybe some of you guys use them. An auto-correcting bow sight. This is a utility patent. Owned by Burris. You guys familiar with this? Most of you, I'm a bow hunter, so I mean, when this came out, I'm like, man, that'd be kind of cool to have. But then, as you know, Pope and Young doesn't allow electronics on the bow if you want a Pope and Young buck or any deer. So I decided against it, but pretty cool. You hit the button, instead of that rangefinder, put the rangefinder down, pull the bow back. Nope, you're up there, bing, you know exactly where you're at. So Burris came out, they got this patent. Well, guess what? As usually what happens, somebody said, hey, that's a cool idea. I think I want to do it too. So then Garmin came up with their Garmin Zero bow sight. All right, so what happens? Now, this is a drawing on the previous patent right there. Notice it doesn't look like any of the sites we just looked at that were the pictures. The biggest thing I hear from clients when they get sued or they're about to sue is, mine doesn't look like that. So what? If it's a design patent, now that's all that matters. But in a utility patent, Spot Hog, good to see you, man. I've been talking about you. You hear me talking about you guys down there? Because I love these guys. And so I brought your trademark up, and we talked about you there. But anyway, it's not about the drawings and a utility patent. Drawings are just drawings, but remember, it's about what it does. It's about the functionality. The drawings are only there to show you how it works. So don't go be looking at drawings. Now, not to bore you, but this is what matters. At the very end of a patent is what we call claims. That's like a deed to property. And notice, here it says an auto-correcting bow sight comprising and. In order to infringe, you got to do and and. If you leave out any one, you don't infringe. Okay, so that's what utility patents are all about. All right, so Burris said enough to Garmin. Got to sue you. Going to sue you for patent infringement. You guys, we got the patent. You don't. You're doing basically exactly what's in the claims. And so they sued Garmin. Demand for jury trial. Garmin does what all of us lawyers do when sued, or when the clients get sued. There's two lines of defense. We don't infringe, that's number one, and your patent's invalid, that's number two. That goes into every single answer in every patent infringement complaint. Okay? That's just law 101. That's what we do. Now, in addition to that, Garmin went one step further and said, oh yeah? We think you're invalid. And not only are we going to fight you out in court, we're going to go back to the patent office and do an IPR, which is an inter-parties review. And we've done that as well in our firm. But basically, the inter-parties review is you go there and say, they've got an invalid patent. And sure enough, Garmin came up with, Garmin's the defendant. They came up with patent A, patent B, put them together. We got you guys. Patent office says you're right. And patent office invalidated the patent. Case over. Don't even have to go to a jury trial. Don't have to go, step one, step two, all done. But these IPRs, they're expensive. Just the filing fees, they depend on the claims. Filing fee in the last one we did was $55,000 just to get in the door. So you're only doing it if you've got a product that's worth doing it for, Like people say, well, geez, if I get a patent, now I've got to go out there and I've got to enforce it. Yeah, you only enforce it if you're losing a lot of money or somebody's making a lot of money. You're not enforcing it if they don't. It's just too much money. All right. Last but not least, copyrights. Probably the most common thing all you guys are doing, because if you got a website, you got some copyright issues. You've got the content, the written content, you've got photographs on there, and they're all protected if you're taking the photographs. So notice the key here is original works. Notice I did not say new. Original is different than new. So a lot of people come to me and they say, hey, can you do a copyright search for me? I want to put up these pictures, I want to put up the... What? If you created them, you get a copyright. So like the Nashville skyline, or Broadway, there's probably thousands of pictures of Broadway, Nashville skyline. Everybody owns a copyright on that took a picture. Now, you take somebody else's picture, that's their copyright. But as long as you're original, as long as you created it, you got nothing to worry about. You got your copyright. All right. What does it protect? Just about anything that's related to literary, dramatic, musical, photographs, content, music, all that stuff. It does not protect facts, ideas, or systems. Let me give you an example. So like say, people come to me all the time, I came up with a new method of shooting the bow. So you put it on your website, and there it is in a nice booklet form. I want to copyright that. All right, so people can't take that and go to the copy machine, but they can look at that and go, now that's a cool way to shoot a bow, and I'm just going to do it. So a patent may protect you, but a copyright's not going to protect you on facts and ideas. All right? When is the work protected? The moment it is created and fixed in a tangible form. Any machine, any computer. So that's right, you get immediate rights and copyright by creating the work right there. Okay? Now, why should I register it? That's what you want to do. Same thing with trademarks. Use the trademark, you get common law rights, but you want to register. You want to register it because, yeah, public record, but here's the big kicker right here. You can't do squat against anybody else copying you unless you have a registration. You cannot go to court and sue. Trademarks, you can go to federal court, state court, if you got a common law. You can only go to federal court on a copyright. That's it. And you can't get in the door unless you got the registration, and that's going to take you 4 to 5 months to get. So that's why you should always register. Now, here's another key point to register. I know I'm getting a little in the weeds, but this is important to know. If, say you create a website, you don't register it. Somebody copies your whole website, copies the pictures. When you finally get your registration and you go to sue, the only thing you're going to be able to get is what we call actual damages. You're going to have to prove what you lost or what they gained off that copyright. And I say, good luck, because that's tough. If you register first and then they infringe, you get attorney's fees, voila, yours truly gets paid. And then number two is you get what we call statutory damages, minimum of $750, maximum of $30,000 per infringement. You don't have to prove actual damages. So that's what you want. And it's dirt cheap compared to trademarks and patents. All right, I'm saving this to the end because if you walk away with anything, man, this is the most important slide for all you guys. And you're going to think I'm out of my mind on this one. But do never send a cease and desist letter. And you're going to say, what do you mean? I've gotten them, I've sent them. No. Here's why. If you send out a cease and desist letter, now you give the other side an opportunity to sue you for what's called a declaratory judgment to say, I'm not doing what they said I did. So when you say the I word, the infringement word, they can go to court, they can file, and they can say, Judge, this guy accused me of the I word. I'm not infringing, I want you to declare it. Now you might think that's all cool and good, and like, yeah, I want that fight. No, you don't, because that fight's going to be someplace you don't want to be. Because if you're up, say in Boston, and you send a cease and desist letter to Texas, they're going to sue you in Texas. They're going to sue you in Boston. So you don't want that. Now, people are like, well, how am I supposed to get their attention then? Common sense, you write a letter, say, like if I were to write a letter, I say, hey, I'm Gary Lambert, Shortell and Connaughton. I represent, Spot Hog. I wish I did, but represent Spot Hog. We have this trademark. You are doing this. Please compare this and get back to me. They read between the lines. Yeah, and I didn't say the I word. I didn't accuse them of doing anything wrong. But I got to tell you, what I love is when I get a client who does have the amount of money to sue, because you want to talk about shocking the other side when they send me a cease and desist and we sue them, up in Massachusetts and New Hampshire. I'm like, amen, here we go. People call me, what do you mean? What do you mean you sued me? Yeah, well, you shouldn't have done an amateur job. Hire a good lawyer next time. Okay, but back to this. What to do if you get one? Because not everybody's got the money to get into the courthouse, right? Or wants to spend the money. You can ignore it. Not a good idea. That gets people upset when you don't listen to them. People want to be listened to. So you want to listen to people. You can negotiate. You can comply if you want to. That's the easy way out. You can respond or hire people like us respond. By the way, you're wrong. Here's why you're wrong. Maybe it goes away. And last but not least, you can sue them. But that's what you want to do. And if there's anything, I think probably, just based upon my clients, this is probably the most important slide that I would keep in mind. Because everybody's going to run into this. Somebody's trying to copy somebody everywhere. Somebody's going to accuse you of copying something. All right. No questions during the show, during the presentation, but do you have any now? Because I'd be happy to entertain them.
What good is a copyright if I haven't registered it? It's worthless, right?
Well, the question is, what good is a copyright if I haven't registered it? It's not worthless because you get a copyright automatically, whether you want one or not. And that date that you have there is important. So the date that you created it, you should always try to document that in somehow, right? And so you can always write that letter, not a cease and desist, but say, hey, Greg, I've got a copyright in this. And so I created it here, and you're doing this, just to let you know, and see what they say. They might just say, geez, wow, we didn't know it. A lot of times, or we made a mistake. Because here's what happens a lot. These companies hire people in the lower strata, so to speak, to put together a website. And these folks are copying stuff all around. Sometimes the owner of the company may not even know it. And they'll just go away. Or they'll correct the action. Because nobody wants the lawsuit, But, if you got a registration, you slip that as Exhibit A in the letter. Now they're like, wow, okay, these guys really, they mean business. They're professional about it,
I know you said you didn't want to talk about it, and I think I know why, but is trade dress the trickiest trademark to try to...
It is. The question is trade dress the trickiest stuff out there in the IP field, the intellectual property field? And I got to tell you, yeah, it is just, the question is, trade dress is complicated, and what if you put white in place of red? You know what the bottom line is? It's what the consumer thinks. Remember how I had that slide up there? So if the consumer, and I doubt the consumer is going to say, wow, Carbon Maxima red, the white arrow, it must be associated with, with Eastman Archery. People aren't probably going to say that. So, but it's always about the consumer. It's never about us. And if the consumer could somehow think that the white arrow is associated with Eastman, I doubt it, but that's what, if I was Eastman, look, I got Exhibit A, Witness A.
Do you suggest trademarking your dress?
Yes.
So it is worth it.
Oh, in this day and age with the global economy and everybody's got a website and everybody's looking at everybody and everybody's copying what I think it's money well spent, and it's not. We do it all the time. That's how I make my living. I enforce patents, trademarks, and defend people who have been accused of patent trademark infringement. So I mean, me and a bunch of other lawyers are making a living off of, and the phone rings every day. So, and we're a small firm. I mean, we got 5 people. I can't imagine what a mega firm does, So, any more questions? We've got a lot of nice background noise, but yes, sir.
What's implied?
Okay, so the question is, as a dealer, a hunting retailer, what's implied when you when you buy products from someone else and you resell them? Okay, the name of the game is if you buy that product, and you're buying it at wholesale and you're selling it at retail, you get a right to do whatever you want with that product because you bought it. Now, if you decided to say, hey, that red Carbon Maxima arrow is pretty cool, I just think I'll make my own and sell them, now that's infringement. But you go ahead and buy, and then you resell, it's all implied that you have a right to do what you want. Anytime you buy anything, you have a right to do what you want with it. Now, like I say, the minor exception on that, when it comes to patents and patent infringement, you saw what the law says. Anybody making, using, selling. So if someone's a patent owner, and even though you bought it from Joe Blow Archery Shop, you're still an infringer. So the good news for you, though, is guys like me that do this for a living, you're too small. Who the heck wants to sue you, right? Right. So you're going after the supplier who's supplying you for patent infringement. But technically speaking, I could put you as a defendant. I could put John Doe bow hunter as a defendant. What am I doing here? It's not worth the money. All right, so the question is, if you get a cease and desist from the at the corporate level, does he have to stop? Correct. All you guys, I hope, or maybe you don't, but there's usually an agreement between whoever you're getting your products from, usually something in writing, that talks about indemnification. If not, that's something you probably should look into, right? So in other words, you buy something from someone else, they normally will agree to indemnify you if you're accused of patent, trademark, copyright infringement. If that's not in that agreement, then the law of the jungle rules, right? Which is every man for themselves. Does that answer your question, though?
Yeah.
Yeah. I'm trying to put it maybe even a better way, but yeah, like I say, the bottom line is this. This show runs on, not this show, the patent infringement, trademark infringement, copyright infringement business runs on money. So people aren't going to chase somebody that's not making a lot of money. They're not going to hire a lawyer to go do that. As if you got to be making a lot of money, you got to be causing somebody a lot of damage before somebody goes to a lawyer. And that's why these cease and desist letters are just like, they're jokes. I mean, people, I would say, this is a rough guess, but for every 100 letters that my clients may get, maybe one, maybe even less, somebody decides to sue, somebody decides to take it one step further. Because they write the letter's cheap. And so if they stop, they stop. If they don't, they don't. You know? Because unfortunately, I guess fortunately for me, lawyers are expensive, litigation's expensive, very time consuming, and you don't do it unless it's worth it.